Good morning, everybody. You know, when I prepared myself to come here this morning, I thought about that decision that I had made 3 weeks ago to come here and address all of you. And I asked myself, why did I agree? Why did I say yes? To come, spend a Saturday morning, share my, we call it intellectual property, with total strangers. What made me say yes? And you know what I realized? I said yes because of compassion. I said yes because of care. I said yes because of love. Because that's what we stand for as human beings. We ought to stand for love. We ought to love one another. Love your neighbor as thyself. Coincidentally, I'm also a Christian. So I've got Christian convictions and I live by Christian principles. I'm a born-again Christian, not just a Christian. So I try to live my life in accordance with the will of my Creator, okay? And the principle that He espouses that is that we should love, right? That love is everything. Without love, we are just a clinging symbol, right? And we make noise, in other words. Anyway, so I just wanted to say why I agreed to be here today. And now I'm going to tell you a little bit more about myself. So I studied law in the Free State, University of the Orange Free State. And I obtained the formal qualification of a BProc and an LLB. At the time, BProc was your first degree and your LLB was your post-grad qualification. And I somehow, in my final year of my post-grad, was recruited by the CCMA, and I started working for the CCMA. And as a result, I developed a keen passion and love for employment and labor law. So I'm a specialist in labor law. I'm an ex-CCMA commissioner. And when I started my practice, however, my principal, under whom I did my practical legal training, told me, you know what, Ronelda? Beggars can't be choosers. And he said to me, if I can give you one word of advice, is that when you do start your practice after leaving here one day, which I know you will, do everything. Be a generalist. Start with all sorts of law. Anything that comes in your door, attend to it. Do it. And I did it. I did it for the first 2-3 years of my being in practice. And then, of course, decided to stick with those areas of law that resonated with me, that I felt competent and capable of dealing with, and that I felt is an important part of my life experience or the purpose for which I'm living to do. So I then started specializing only in labor and employment law, family law, and I do services also for the pro bono clinic at Constitutional Hill with Elsa B. Steenhuisen. I do and help with some of their cases every now and then as well. And we also do a little bit of civil and commercial law. So, so I've got my own practice. I've had it now for 9 years. This year's my 9th year. And I practice out of the East Rand. My offices are in Bedford View. And we're a small firm. And we live for the people. We live for the people. We really do a lot of our work that we do is in order to assist. But at the end of the day, you know what? The reality is that we need to pay our bills, isn't it? We also have mouths to feed. So we do have to charge, and we do have to conduct a very careful balance with how much we can provide in terms of free assistance and how much we can provide, of course, in terms of generating an income. They demand their salaries at the end of the month, don't they? Anyway, I'm here this morning to understand your needs and to see to what extent I can spontaneously and on the moment, by the fly of my seat or by the seat of my pants, able to assist you in your questions. Look, I don't profess to know all the answers. If I can't, answer a question, I will refer you to a resource, or I will take down your details and maybe pop you an email or pop you a WhatsApp. So let's try and see how we can engage, how best I can understand some of the questions that you may have. And that's me. Oh yes, I'm married. And oh yes, I don't have children. And I'll be celebrating my 3rd year of marriage by the end of this year. Yeah, thank you so much. Thank you so much. Thank you, Penny.
Pleasure, Ronelda. Thank you for that introduction.
Yeah.
Okay, so let's just work it like this. If you want to ask a question, raise your hand and I will come to you.
Stand up. Hi.
Hi, good morning.
Good. I
thank you.
know my soon-to-be ex-wife for almost 30 years.
Yes.
I filed for divorce in 2017, February.
Okay.
All right. She went to an attorney.
Yeah.
After that, she went to LegalWise.
Yes.
And we had a meeting at the end of 2017.
Okay.
Middle of 2019, she moved out to another property that we have, a townhouse.
Okay.
So I've had the house to myself, right? She's got little things like a kumbi, that she used to transport kids with.
Okay.
Parked on my property. She's got like a big vending machine in the way that's parked in my property.
Yeah.
So over the years, we've sent her letters with my lawyer saying, please remove the kumbi and return the house keys and within X amount of days or else. And she decided to do all else. She just remained silent.
Yes.
Nothing's happened.
Yes.
There's been nothing forthcoming from her side.
Yeah.
She's now with the Wits Law Clinic.
Okay.
So there's been nothing forthcoming from her side in terms of the divorce. I think she's in a very comfortable position where I'm paying the bond, the electricity, levy, everything for their townhouse. So her expenses are low.
Yeah.
All right? And I think if she keeps it, the status quo as it is, she'll continue living this life. She's got a full-time job now. She just started end of last year. So we're not getting anywhere. No matter what correspondence we send.
Yeah.
I mean, I really want to get divorced.
Yes.
So hasn't been any correspondence from her. Very small, very little. It's like I'm reading through it now. I think it's all delaying strategies. And I'm finally going to see my lawyer this week, fully armed with everything. How do I get things finalized? By the way, we had, I think it was early last year, seen the, what do you call it? The magistrate, what do you call it? The pre-trial conference.
Oh, you had a pre-trial conference? Okay.
Last year, January.
Okay.
Early this year, we had the family advocate meeting.
Yes, okay.
Right. The only issue we were fighting about was about joint custody for my youngest.
Okay.
I have 2 adult children.
Yes, yes.
They live with me.
Okay.
Right. So I managed, it was a tussle over a couple of years. I managed to get joint custody of my son in March this year through a proper social worker.
Yeah.
Everything's been working fine. So there's no problem. There's no fighting about assets or anything at this stage. No one's claiming, I want this and I want that. So there's just like no movement forward.
Okay.
If you can just
certainly
help me. I want to get divorced next week.
100%. Okay. All right. Thank you. Can I just quickly, for interest's sake, ask, are you married in community of property or out of community of property? I see. Okay. So this does happen often, that there are so much delay in finalizing a divorce. Do you know that you can get a divorce within 3 months? I think that's how long it took me to get divorced, because I've been divorced and I remarried. But I did my own divorce. At the time, I just started, it wasn't very long after I finished my articles. So I was also still young and inexperienced, but I went ahead with it myself. And I got, maybe because of course I've got formal legal training, but it's possible to get divorced within 3 months, and perhaps sometimes a bit longer and sometimes even a bit shorter, depending of course if the divorce is going to be opposed or unopposed, and also of course depending on whether you are able to find and locate the person, your other half, if not living together, to effect proper service of the summons, because proper service also ends up delaying things. If you can't serve the divorce proceedings on your spouse, it does cause, delays as well. But anyway, to get back to your question, so you've already, yes.
Unopposed.
So it's an unopposed divorce.
Unopposed. There's nothing that should stop it.
What do you
from
mean
moving.
unopposed? So with who did you conduct a pre-trial conference?
With the attorney in,
Yeah,
a
her
judge.
attorney, her legal
Sorry, a judge. Pre-trial conference with the magistrate.
And did she attend with her representative?
Yes, and I did with mine.
100%.
Yeah.
So
a
there's
year.
something.
So
Yes.
it's unopposed. A
Yes.
year ago, she signed everything.
Yeah.
There's nothing to stop it. What's stopping it? What's
Yeah.
slowing
so
it down?
did she file a plea?
No.
Okay, all right. So it is a unopposed divorce then in that regard. But can I tell you something, guys? Right? Especially if you approach the district courts, the magistrate courts for your divorce proceedings. Whether there was an appearance to defend or not, no divorce is ever unopposed. I can tell you that. Because the magistrate, it's a matter of changing somebody's status. Right? So status matters. There needs to be input from the persons whose status are potentially going to be changed. But if there has been no appearance to defend and every effort has been made and you got the evidence to show that it was served on the spouse and you appear in court, if you applied for a trial date and you appear in court and the magistrate inquires about, okay, so where's your wife or where's your husband? No, this is an unopposed divorce. They didn't enter an appearance to defend. Can you demonstrate that there was service of the summons on that person? And you will have to provide that proof. Only once the magistrate is satisfied that there was sufficient proof, that the person was made aware of the set-down date. So when you get a trial date, that notice of set-down also needs to be served on that person, even if they did not enter an appearance to defend. Okay? Because the magistrate wants to be satisfied that when they make a decision to change somebody's status, that they waived their right to be heard. Okay? Because the principles of natural justice applies in these matters. Okay? So if you do get a trial date, make sure that when you go to court, if you are unrepresented, that you have all the necessary evidence and proof that you have served the summons, you have served the notice of trial or notice of set down, and the person or the spouse that you are trying to divorce from has made a conscious choice not to be in court, not to defend the divorce proceedings, okay? Then you have a better chance of the magistrate proceeding than with the matter granting your divorce decree in absentia.
Okay.
Yes.
If in the pre-trial conference date,
Yeah.
it was proven that she had been served with a summons,
Okay.
all right?
Yes, and
So-
it was part of the pre-trial minutes.
Yeah. We don't have a trial date.
Yet.
We haven't
Okay.
applied. I spoke to my lawyer now. He
Yeah.
said it takes next year. I mean, the courts are full
Yeah.
with COVID, everything, so it's going to take a year. So,
Yeah.
so with all of that out of the equation, how do we finalize?
Proceed. Okay.
Yeah.
So, firstly, it's a good thing that there was a pre-trial conference and that she attended, right? And because the pre-trial minute, you can agree or document all of these things already. And if it's signed by both parties, that is what the magistrate relies on. Okay, so it's always good to have a pre-trial minute because you are then bound by what has been agreed in that pre-trial minute. So if the person agreed in the pre-trial minute that, number one, I am aware of the divorce proceedings, I have received the summons, I agree that I do not wish to oppose the divorce, and that minute is signed and filed in court, then of course the magistrate has got all the answers and all the evidence it needs to proceed in absentia. To talk about the date, okay, this is a court system, right? It's not subject to your attorney's control, it's not subject to your control, it's not subject to my control. You have already progressed in the matter because when you first started your question, I thought maybe nothing was done. There was just correspondence back and forth, just letters back and forth, and there was no processes followed in terms of the steps of the litigation. But You have actually mentioned that you have done all the steps. You've even got the pre-trial date. It was conducted before the magistrate. So the next obvious step is that you can apply for a trial date. The court file needs to be paginated and indexed, but that's going to be taken care of by your legal representative. If you are unrepresented, you can go and you can index and paginate the court file yourself. All it is, it might sound like a fancy word, but it's not fancy. All it is that you just draft an index to say summons, page 1 to so-and-so. Return of service, page 1 to so-and-so. Notice of intention to defend, page 1 to and then you number the pages. That's pagination. It's just writing the numbers of the pages. Good morning, ma'am. So it's a fairly simple thing to do. Draft your index, go to the court file, make sure that all the documents are in the court file. If there's nothing, make a note which is not there, and bring your copies along so that you can include in that court file the documents that are not there. Okay? And number the pages, and then once that has been done, once you've indexed and paginated the court file, make sure that a copy of that index is also served on your spouse. Okay? So that they also have a copy of the index. And once all of that is done, once you've got a pre-trial minute filed in court, once you've got a court file paginated and indexed, nothing precludes the court from allocating a trial date. Okay? The matter is trial ready. You can get a trial date. Okay? Yes, you are now obviously dealing with the unfortunate and unforeseen consequences of the COVID-19. Yes, matters that had been scheduled during the COVID or the lockdown period enjoy preference, because remember, those matters had to be taken off the court roll. Okay? So those matters will then be enjoying preference in terms of a new date being allocated to those matters. So it does mean that the year is now extended, so to speak. Okay, matters that would have been resolved by this time are now only being enrolled on the court roll this time. So new matters, new dates will ultimately end up being allocated in the new year.
Have a round table meeting and get divorced now before the end of this year. We got to wait for the court date.
So there's one thing I want to mention here. Remember, you said that your divorce is unopposed. Now, usually, ladies and gentlemen, is your proceedings out of the High Court or the Magistrate Court? The Regional Court, yeah. So usually with these proceedings, if it's an unopposed matter, you can get a date very quickly, because it doesn't have to go on an opposed roll for a trial that will take forever. Unopposed matters there could be quite a number of unopposed matters set down on a specific day, because they will be quick. All the magistrate will do is ask you the standard questions through your legal representative and grant the divorce decree and move on to the next one, right? So usually unopposed matters gets a trial date far quicker and far sooner than an opposed divorce, all right? So make sure that your attorney sets the matter down on the unopposed roll, because then you are likely, of course, rather, to get a date sooner rather than later. But there's no other way to get divorced until you appear before a magistrate or a judge. Nobody else can divorce you.
Thank you.
In this country. Yes, ma'am.
Thanks, Ronelda. I just wanted to ask, is the High Court now open to hearing opposed matters? Just to get an indication of what kind of court dates we're looking for next year.
Yes.
Because okay, so are they hearing it now? They are open.
There has been a directive published on the 20th of September, I think. If you want, I can make a copy available to Penny. But the directive specifically stipulates that the high courts are open. And they are now proceeding as normal, and people have got access to the court. I do know that the Pretoria High Court still doesn't allow people to access the court, but your Johannesburg High Court, they've indicated that they are open and available for access.
They're working everything by email.
Yes.
3 months just to scan
Yes. 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 Yeah, with case lines.
Yeah.
Okay. Sorry, I lost my grip. There we go. It's back. Yes, thank you so much. What is your name?
I'm Nikki.
Nikki. Hi,
Yeah,
Nikki.
hi, Ronelda.
Yes.
I just want to add to that, because I've been, what was the date of our court? I've been in the High Court in a case that's for 2 months now, and it's been online.
Yes. Yes.
And that's in the Johannesburg High Court. So
Yes.
I know that it's been, and it was operational even before that.
Yes. Yes.
So I think maybe it was only not operating for about 2 or 3 months in the hard lockdown level 1 and 2.
Yes.
Sorry, it's the other way around here, 5 and 4. Yeah, okay. But I do have a question of my own.
Yes, Nikki.
Two questions. I would really like to know what your knowledge and awareness is. I'm sure everybody wants to know of narcissism itself and the dealings generally in the South African environment and the legal awareness of it that seems to be growing. We know that I've done a little bit of research in this regard in the UK. In 2016, I think there was an establishing case, and there has been notifications. I don't know the legal terminology. Sent out in the legal fraternity to update and inform and encourage legal personnel to inform themselves about narcissism. We do know that in the UK. There was a case here in South Africa in the last few years where a murderer was convicted, and in his conviction his diagnostics was that he was a narcissist. So we do know that the awareness is growing. So I really would love to have that question answered, and then I have another personal question in terms of the police that I'd like to ask you afterwards.
Certainly.
Thanks.
Okay, certainly. So my experience with narcissism has been simply personal experience, firstly. And secondly, some of my clients whose divorces I'm handling are married to narcissists. And in the process, of course, I gained exposure in understanding the various tactics and tantics that narcissists apply. And what they subject, their spouses to during the course of marriage, and even in intimate relationships with outside of a marital relationship. Because as we know, even if you have a relationship, you're just living in with somebody, you could still experience those kinds of behaviors. And so definitely I agree with you. There's still a lot of ignorance around the issue of narcissism in our courts. Most judges don't really bother to au fait themselves with the principles or with narcissism and just rub it or make it down to be insanity or craziness or emotional outbursts of the victims of narcissistic behavior. We as legal professionals, well, me personally, I've gained interest in this particular area. Because I wasn't aware really at the time when I was subjected to this kind of treatment, what to categorize it as. So when I started practicing and when I started representing individuals for their divorces, I became a little bit more acquainted with the subject, and more so, especially over the past year and a half, 2 years, I've been a lot more involved in the issue of narcissism. So we are growing in terms of our awareness on this particular subject. By the way, today it's World Mental Awareness Day, isn't it? Yeah. So I think it definitely is growing, that we as legal professionals are starting to also embrace the reality of these things, because it's something that we would just disregard, isn't it? It's something that we would put off as a mental illness, and it's something that we sometimes put off as a figment of the imagination of the victim of narcissistic behavior, which is very unfortunate because it's so real, okay? And the effect of it is so harmful and so damaging. And I think justice cannot be done if a judge or a magistrate doesn't understand narcissism. And the unfortunate reality is that current judges promotes it, enables it, because they themselves might even be narcissists. So it's going to be a difficult battle, ma'am. It's going to be a long battle. We are in the beginning phases, as you say, of creating awareness, of becoming more aware of these kinds of behaviors, but we are very far from there. I can tell you the majority of judges in the high courts just don't even bother with this issue, right? So, yeah, what can we do? Yeah, your personal question.
So my particular experience is I can almost handle that problem because we know we're kind of almost in a societal war against this pathology,
Yes.
and which incriminates innocent people and, as you correctly say, does not bring about correct justice,
Yeah.
which is an injustice in the justice system in itself. So that is a natural evolution that has just got to happen.
Yeah.
So I can deal with that, and I've had tremendous growing curve, as I'm sure a lot of people here have, because you're forced to. But I'm representing myself, and I've learned about the legal system, but what I find extremely difficult to deal with is that when I've learned about the correct protocol and procedure, which some of which you have explained to us today, and the police and the authorities do not follow those procedures, then I haven't got a hope in hell.
Yeah.
Because if a policeman takes the law into his own hands and decides, it's just a neurotic woman who's been beaten up by the men in her family, and you know what, it happens every day and we can't be bothered because there's far more serious things to deal with, and he actually starts by all accounts writing a statement to the prosecutor saying this case has no merits, then I'm dead in the water. I mean, and the recourse to put pressure even just on the legal system and personnel just to do their normal jobs and transactions as per regular stipulated protocol, that is what I'm dealing with right now. And how do you suggest, do you have any advice?
Yeah. Ma'am, it is a very unfortunate scenario when the enforcers of these laws and these regulations are unwilling to comply therewith. And it's very difficult when you are an individual in that situation to actually get them to comply. So when you, for example, get an unfortunate outcome of that nature where they say that the criminal case or the protection order, whatever it is, should be dismissed because it was based on somebody's imagination or mental instability or mental ill health, whatever the case might be, then there obviously are things called appeal processes, right? Where you can take the decision of the magistrate on appeal. The only challenge with these things is, ladies and gentlemen, it costs. Okay? And an appeal is so technical and it's so sophisticated that it's not easy as a layperson to do it yourself. Although the processes are there, the challenge is how do you make use of it? How do you access it? Right? And I suppose that's where the pro bono clinics come in, but sometimes they are so inundated that they might not even take your case on. And they have a very strict criteria in terms of who qualifies to access those services on a pro bono basis. Okay? And the challenge also is that even if you do appeal that particular decision of that court, it takes time. In the interim, what do? Okay? Because the wheels of justice do turn slowly, unfortunately. Okay? They turn very slowly. But there are other avenues, such as urgent applications, depending on the nature of what it is that you're trying to accomplish. You can go to your attorney and ask for an urgent application to prohibit certain conduct or to require certain conduct to take place, right? And then if you are in a marriage situation and it pertains to, for example, maintenance or taking care of the kids, providing the necessary support or financial support for your kids, you can do. And if you are in the process of a divorce or about to go through a divorce proceedings, you can also do a Rule 43 application, which is that application that assists you to get that help even prior to the divorce having been instituted or having been finalized, right? So I suppose in the interim, while you appeal, there are some other avenues recourses that is available to you. But again, it all comes down to your resources at the end of the day.
May I just say that I can't even get this case into court. I would love to be at the point of having an appeal, because I've got J88, there's nothing, I've got everything that is required to prosecute the perpetrators. But where it's stalling is that they're having tremendous success in keeping it out of the court. Because when they know that my evidence is overwhelming, that once it does come before a magistrate and the procedures do occur as they are supposed to occur, they don't have a hope in hell. They know that.
So what we often do, we do apply a little bit of pressure, right? Even us as legal professionals, because we often encounter delays even with getting the service done by the sheriff, because the sheriff is in cahoots with the spouse or whatever. So there is a commission for the sheriffs or body that regulates the behavior of the sheriff. So I often find myself reducing the situation to writing and threatening the sheriff that I'm going to report them to that commission for disciplinary action, right? So they can be subjected to discipline, the sheriff's office. In particular, in the courts, I was going to ask you, whichever court it is, there is a chief magistrate that is responsible for the conduct and the behavior of other magistrates in the court, as well as the front desk, the clerks, okay? So a recourse could be to approach the chief magistrate with your concerns, with your queries, and maybe do a formal complaint in writing and get the chief magistrate to then assist you in the matter. If the chief magistrate himself is causing the delay, then you have to obviously escalate it a little bit higher, okay? But there are processes to lodge complaints against these officials. And perhaps sometimes, if there's no other way, you're going to have to consider that.
And what with the police? Because I can't even get the papers from the police station, which is a few hundred meters down the road in a small town, to the court. Took us 20 months just to get the right papers in the right file to the prosecutor, who then in 7 minutes promised us, he made a judgment. He said this is going to trial. He called for a J175, which is a summons, I believe. And we
summons to appear.
Correct.
Like a subpoena.
Then then it just stalled. Completely stalled, and the police are saying no, the prosecutor didn't give them what they needed, and the prosecutor said no, the police are refusing to serve the summons, and we're just stuck in the middle. 100%. And one of the accused is in the meantime died. So now that case,
falling flat.
Yes.
So what often happens is, I know that a lot of lay people actually direct complaints to the National Prosecuting Authority. Okay? So write a letter, and they actually do respond to your letters, hey? Even if you are an individual, they do respond. So maybe address a complaint to the National Prosecuting Authority, and I would also perhaps suggest copying in the Minister of Police, if depending on the circumstances of the matter. But definitely there is forums, there is levels, there is protocols that you can follow in order to get this issue, addressed or escalated to the next level. Yes, sir.
Hi.
Nigel, sorry. I need glasses, eh?
Being the new husband to Nikki, I've experienced a lot of the agony that we've had to go through.
Okay.
Tell me one question I want to ask on an overall legal thing.
Yes.
Is there not somewhere a list and a system of protocols that everybody can follow?
Yes.
For argument's sake, we've got a police officer that investigated a crime, never went to the scene of the crime, he never interviewed the primary witness, he never interviewed the perpetrator, okay? He never took statements from any of the other witnesses. The two statements were one constructed in a postnet, and the second one was constructed by a lawyer. And he then proceeded to say that there was no merits for this case to proceed. We've got photos, J88s, all the evidence. What the public are ignorant about is what are the procedures that the police should follow,
yes.
in an investigation.
100%. It's all contained in the Criminal Procedure Act. How they should handle evidence, how they should handle a crime scene, how they should collect the evidence. It's contained in there. Okay? And what a police officer can and cannot do. So it would be a source, I suppose, of guidance to go through the Act. Look, it's a very vast Act. It goes up to 400 and something, Section 400 and something. So it's quite a massive mammoth document. But you can obviously isolate the relevant sections that relates to your scenario and perhaps have a look at that. There are also directives that are issued for courts. You get the civil court procedure directives. You get the magistrate court's directives. And I think there would be a similar version for even for the police. Okay? And these directives are basically to say the day-to-day operations of a court. How does it happen? What needs to happen? So that's apart from the Magistrates Court Act. That's apart from the High Court or the Supreme Court Act, but it's the directives that guides you on the day-to-day. It even tells you how to address the magistrate, how to address a judge, what to wear, how to index and paginate a court file, who to approach to assist you with all of these matters. So the court directives are quite helpful as well. Court directives. Okay, and they are court. Yes. Definitely, it's also covered. So in the regional court directives, it's covered in there, right? Okay, hi, welcome. No problem. Yes, ma'am.